Harold Bonnell, it's case number 25.
It talks about his pending felony charges in Wexford County. He actually pled to CSC third, Judge. It does say second. I showed it to the prosecutor, Judge.
Okay, we'll make that change.
On OV10, Judge, that was scored 15 points for predatory conduct. I think this is just a one-time action. So I think it should be scored 10 because of her age.
I didn't have enough information to believe that it was appropriate at the time of scoring to rate it as predatory for ours. I do believe it would be predatory for Wexford's, but that occurred after ours.
Okay, so you agree that offense variable 10 would be scored at 10 points?
Yes, Your Honor.
Penetration. There was no penetration in our case. There was in the Wexford case, but that occurred after this case.
And Ms. Robinson, you agree that for that variable, we score just the conduct involving the sentencing offense?
Yes, Your Honor. With the conduct just involving this offense, there was no penetration for ours. So that should be 0.
All right.
All crimes are to be included without regard as to whether they resulted in a conviction.
Thank you. So we'll score 25 points for offense variable number 13. Challenges to the advisory guidelines?
No, Your Honor, no further challenges.
All right, so we've got prior record variable level C, puts us
0.
0 to 25 with the habitual offender third.
0 to 25, yeah. Okay.
Anything that you want to say on his behalf?
Well, Judge, he brings up a couple of points. On the record, the habitual offender third was dropped. Court could clarify that for Mr.
So what my notes indicate was on November 4th, the offer was plea as charged, which was to more serious offense of criminal sexual conduct in the second degree.
Yes, sir.
And then that was dismissing the habitual offender at that point. Some further discussion, and I think they determined that any penetration did not occur here. That was in another county.
Your Honor, yes, my notes indicate that the offer was the CSC third with the habitual offender.
And I think that was a confusion, Judge, was that first plea was a second without the habitual, and then our subsequent plea was fourth with the habitual. So I think that would clear that up.
Yeah. Anything else?
I believe it indicated that the court would consider in the term of probation. I think that falls within the guidelines. So we'd ask the court to consider. So I believe that sentence there is going to be probably more than what we have here because it's a more serious offense. But we're asking the court to consider county time for Mr. Bonnell.
So I did not indicate to Mr. Bonnell that I was considering a county sentence in terms of any sort of Cobb's agreement whatsoever. What I most likely said that it would be sentenced consistent with the advisory guidelines.
That was my recollection. That wasn't his.
Yeah. So, I didn't rule it out, but I didn't say I'm going to, he's going to get a county sentence.
No, I didn't mean to give the court that impression.
Is there anything that you want the court to consider?
Since I've been in incarceration, I missed out on my daughter's surgery. That's 9 months old, and I missed out on my son being born the 13th. And I just want to let the courts consider that if I did get county time or probation, that would show, that I'm not a bad person. And before I went to jail, I did a CSE class. I passed that, and I just, I'm not some bad person or anything. I understand that what I did was wrong, and I really feel bad about it, and I don't want to be put away and not be able to be in my kids' life. I have 11 kids, and I had custody of my 9-year-old daughter. So I'm asking the court for a little leniency, and, I'm already getting sentenced up there. Their guidelines are 15 to 24 months. So I'm just asking, just to show you and prove to you that I'm not this evil person, and I'm not a career criminal. I mean, my last felonies were 25 years ago. I haven't been in trouble in 25 years. Haven't done nothing wrong besides, I'm at this. And like I said, I admitted that it was wrong, and I'm missing out on a lot of important things in my life. And I understand that's worse than, doing prison or jail, not being in my daughter's life with brain surgery and seeing my son be born. I haven't even gotten to see my son. So I'm asking, to consider that and let me prove to you that I'm not this bad person, and whatever I have to do, I will do, and I will show you everything.
Well, it's one of those things where it's hard to separate, decent people who do bad things, and at what point do they cross the line where they become a bad person? And to me, I don't really have to make that distinction, because to me, it's almost the same, that a person, you, did bad things. I mean, I can't imagine what was going through your mind, or even what's going through your mind today, to think that you're not a bad person. You raped a young person. You're 48 years old.
Yeah,
you
right.
raped a young girl. You ruined her life. And how you can sit there and think that you're not a bad person, and you want this court to feel bad for you that you haven't seen your daughter or haven't seen your son. I mean, I feel bad for your family. I don't feel bad for you one bit, because you earned this. These are the consequences of your action. You shouldn't be around any kids.
I did not rape her.
Okay, well then let's let you withdraw your plea. See what happens. See what a jury thinks. Is that what you want to do? You don't think you did anything wrong, you can withdraw your plea.
Well, you said I had sex with her here. I didn't have sex.
I didn't say you had sex with her here.
You said I raped her, and I never.
You did. You did it in Wexford County.
I never raped her.
All right. Well, I guess we can agree to disagree.
This exchange completely changes the tone of the hearing. Up until now, the defendant has focused on his family, his children, and the opportunities he's missed while incarcerated. But the judge's response makes one thing crystal clear. The court is far more concerned with the harm done to the victim than the hardships the defendant now faces. When the defendant continues pushing back on the judge's description of what happened instead of fully accepting responsibility, it creates an even bigger credibility problem. In sentencing hearings, genuine accountability often matters just as much as the legal arguments. What do you think? Did the defendant damage his own chances by continuing to argue, or was he simply trying to clarify his position? Let us know your thoughts before the prosecutor delivers the state's final argument.
Anything that you want the court to consider?
Yeah, and I'd like to put on the record, family of the victim is here, I believe the victim is with them. They have indicated they don't wish to speak, but just make an argument on their behalf to the court that this isn't even a crime that just affected one person. It impacted the family, and that is because the child that the defendant has not seen is the nephew of the victim. The defendant had a partner, and what ultimately it came down to is whether or not they were legally married at the time. But either way, this was her older sister's partner, her older sister's, baby's father, and he took advantage of her and had sex with her. And the fact that he can sit here today and try to minimize what he did, it's really difficult for me to listen to. I think it's probably difficult for them to listen to. I think it shows that whatever metric somebody used to say that he, quote unquote, passed a sex offender class, that metric is broken. Because if he does not take responsibility for what he did, he believes that it should be minimized, that he is a danger. He is somebody who is placing everybody at risk, And he says he hasn't been in trouble in 15 years or in 25 years. So I understand maybe he doesn't have any felony convictions in that long, but he has a domestic violence conviction from 2015. So maybe he doesn't think that counts as being in trouble. He's dangerous. He is somebody who not only, took advantage of a young girl here, he then went elsewhere with her up to, I believe, his home up in Wexford and escalated that behavior. I would ask this court to sentence him to the top of the guidelines. I believe that he has shown through his actions in here and then the continued actions in Wexford, as well as his comments here today, that he's dangerous and that there's nothing else that is going to keep anybody safe except keeping him incarcerated. Thank you, Your Honor.
Yes, the court finds that the advisory guidelines would suggest a sentence between 0 and 25 months. The court's going to exercise my discretion so that it's consistent with the advisory guidelines, consistent with the plea agreement in this case. It'd be the sentence of the court that this defendant served 25 months on the minimum to a maximum of 4 years with the Michigan Department of Corrections. He's to have no contact with victim in this case. There's a $130 Crime Victims' Rights Fund fee, a $60 DNA fee, a $68 state cost assessment used to register as a sex offender. If this crime had a higher maximum penalty and if the advisory guidelines were higher, you would get a higher sentence. You take no responsibility for your actions. And I can just tell you that if
等李燕, the judge imposed a sentence of 25 months to 4 years in prison, along with mandatory registration as a sex offender and strict no-contact conditions with the victim. But perhaps the strongest message wasn't the prison term itself. It was the judge's conclusion that the defendant's continued refusal to fully accept responsibility could affect his future, including any chance of parole. Throughout this hearing, the court repeatedly emphasized that sentencing is not only about punishment, but also about accountability and protecting the public. Whether you agree with the outcome or believe the sentence should have been different, this case is a powerful reminder that words spoken during sentencing can carry just as much weight as the evidence presented before it. If you found this courtroom breakdown informative, don't forget to like the video, share your opinion in the comments, and subscribe for more real courtroom cases and in-depth legal breakdowns.
you continue with that attitude and belief in the Michigan Department of Corrections, you will not make parole, which would be fine with me.